Good morning, good afternoon, ladies and gentlemen. Welcome to the SIAC-RAA webinar titled Permanent Arbitral Institutions and the Future of International Arbitration in Russia. My name is Suen, SIAC's Business Development Manager Legal, and I am pleased to be your MC. The international arbitration community in Russia was abuzz earlier this year, when SIAC became one of the latest foreign arbitral institutions to be registered as permanent arbitral institutions under Russia's federal law on arbitration. Our panelists today, who are leading arbitration practitioners, will be discussing various issues, and I'm very excited to introduce them to you. They are Mr. Vladimir Vale, partner of Baker & McKenzie, Russia, Mr. Eugene Tay, partner and head International Arbitration Asia of Mayer Brown LLP, Ms. Anna Zabrodsky, Specialist Partner of Borenas Attorneys Russia Limited, Mr. Roman Zykov, Secretary General of Russian Arbitration Association and partner of Mansour's. Moderating today's session is Mr. David Goldberg, partner of White & Case LLP. If you have any questions during the session, please send them through using the Q&A function, and our panelists will try their very best to answer as many questions as possible. Without further ado, I will now pass the time to David. Thank you.
Thank you, Suen, for the introductions. Good afternoon, good evening, good morning, everyone. It is my pleasure to moderate this session today. The topic is interesting and timely, taking into account that earlier this year, two institutions received registration in Russia as permanent arbitration institutions. And no one, in my view, or at least me, really understands the significance of that and what it means both for the arbitration community, for the users, for the arbitrators, court system, etc. So this is what we'll try to tackle within the next hour or so. We have four very qualified to speak on this topic speakers or presenters who will each introduce a topic for discussion, and then hopefully we'll have some questions and a lively discussion. So first speaker is Vladimir Vale, who is well known both in Russia and worldwide. He has held so many different positions with all the major arbitral institutions that I will not even list them. But for the purposes of today, what is important is that he is chairman of the board of the Russian Arbitration Association. And apart from being a partner at Baker & McKenzie, he has been teaching arbitration and has been a very active promoter of arbitration, both in Russia and worldwide. And he has been the, I would say, grandfather and architect of the ICC Academy, which, in my view, has been a scene-changing event, if you like, although it lasted, what, 2 or 3 years for arbitration in Russia. So Vladimir will speak about the licensing and the impact of this licensing. Then we'll proceed to our next speaker, Anna Zabrodsky. Anna is a partner at Borenas law firm in St. Petersburg. But apart from being one of the leading dispute resolution practitioners in St. Petersburg, and of course, she is known in St. Petersburg as head of disputes practice of Borenas. She is also heading the fashion and lux practice of the firm. And this is something that makes her very different from all of us here. She actually does something interesting apart from arbitration and life. And that interesting is on the border of dispute resolution and brand protection and development. So Anna will share with us her views on what are the recent developments in the international arbitration in Russia and also what users need to know if they have a seat in Russia or if they need to enforce an award in the Russian Federation. Then we will have Roman Zykov. Well, Roman is known to everyone, first of all, as the Secretary General of the Russian Arbitration Association. But that is his hobby. And most people don't realize that he is a very active arbitrator. He has a very, very busy practice as an arbitrator. He also writes and authors and co-authors and edits a number of very interesting deep publications, including the famous Russian Arbitration Association surveys. And he will speak today on the sanctions based on yet another survey that the Russian Arbitration Association is preparing. And he will compare the results, or he will share with us something that is not public yet, something that has not yet been completed, in comparison with the similar survey a couple of years ago. And then finally, we will have someone from Singapore, a very experienced practitioner, who has more than 20 years experience in international arbitration. Eugene Tay. He is a partner at Mayer Brown, but he has a wealth of experience both in Singapore and worldwide. He has been practicing in London, in Paris, in Washington, D.C. He actually trained as a barrister at Fountain Court, which I found to be very interesting. And also, he is on the panel of arbitrators and conciliators at ICSID. So his practice is wide, both within the commercial arbitration in Singapore and outside of Singapore, and in investment arbitration. So with these speakers, I think we will cover the most interesting topic that people sometimes wonder what's going on in relation to seats of arbitration, what are the popular seats of arbitration, where Russian disputes are going. Actually, when looking at Vladimir's profile, I saw one of the articles at Moscow Times in 2000, I think 15, April 2015, saying, well, it was actually called "No Country for Russian Disputes." Interesting view he expressed then, and that was 2015. So what his views now, we are going to hear right away. So Vladimir, your floor. Thank you.
Good morning, good afternoon to everyone. Thank you, David, for an introduction. Indeed, 5 years ago, when the licensing requirements were introduced in Russia and the sanctions were introduced against Russia, a good question arose where Russian disputes would go. And at that time, it was suggested that the disputes will go to Asian centers because Asia are pretty far from anti-Russian sanctions. But at that time, it looked for me a little bit exotic because Singapore and Hong Kong are 8 or 10 hours flights from Moscow. And it was difficult to imagine that Russian companies will go to Singapore to resolve their disputes, apart from traditional European centers. But these days, we know the situation is changing, and I personally, in my portfolio, have already a couple of cases pending under SIAC rules. But let me come back a little bit to this permanent arbitration institution status in Russia, which Singapore Arbitration Center received this year, and what it really gives to SIAC and other institutions. Just to remind you that this license requirement was introduced in 2016. And the story why it was introduced was pretty interesting because at that time, Russian government was mainly concerned with, let me put it this way, not reliable arbitration institutions in Russia, domestic arbitration institutions. And in order to stop these institutions from operating, the Russian government introduced licensing requirement for Russian arbitration courts. And at that time, I remember when we discussed the draft, I told to the Ministry of Justice, look, I mean, if you introduce licensing requirement, it will be easy to avoid it just simply by creating arbitration court abroad. And the same people who are abusing arbitration in Russia will do it abroad and then come to Russia as foreign arbitration institutions. And there was, by the way, a story with so-called Singaporean arbitration managed, Singaporean arbitration court managed by this funny Russian people. They tried to enforce this award in Russia, but it was enforcement was denied. So the reply from Ministry of Justice was that, okay, if there could be abuse by Russians establishing foreign arbitration institutions, then we'll introduce a licensing procedure also for foreign arbitration institutions. And then, of course, we said, well, but foreign arbitration institutions highly unlikely will follow all the requirements which you introduce for Russian arbitration courts because are very complicated, having list of arbitrators and so on and so forth. They said, well, we will have licensing for foreign institutions, but a light one. The first light requirement for institutions, light not in real sense, was that they were supposed to have a branch in Russia, but no one institution had appetite to open branch in Russia. So after a couple of years, this requirement was abolished. And now for foreign arbitration institutions, the requirement is pretty easy. They make an application, and if institution has the status of recognized arbitration institutions, then it will get permission from Russian Ministry of Justice. And the first institution applied was Hong Kong Arbitration Center, then SIAC, and this year we received permission for SIAC and ICC in May of this year. What this status really gives in legal sense to the institutions. Wait a second. This permanent arbitration institution status allows international foreign arbitration institution to administer international disputes seated in Russia, where place of arbitration is in Russia, with exception of corporate disputes that require special corporate arbitration rules and state procurement disputes. However, the status does not give a foreign arbitration institution to administer domestic arbitration without a foreign element, without with one exception, certain disputes related to special administrative regions. That's it. What are the corporate disputes with a foreign element? Normally, when we talk about corporate disputes, we have in mind share purchase agreements and shareholders agreement. Both types of disputes could be administered by foreign arbitration institution. That's very important because Russian arbitration reform introduced a special concept for arbitrability of corporate disputes. They're conditionally arbitrable, and one of the conditions is that foreign arbitration or domestic arbitration institution is licensed by the government. So this permission from Russian government allows SIAC and other institutions to administer Russian-related corporate disputes, including those which were required to have place of arbitration in Russia, like disputes under the shareholders agreement. There are some other corporate disputes listed on the right side of the screen and highlighted in red, which require special rules for corporate disputes from arbitration institutions. These disputes could not be submitted to a foreign arbitration institution, but frankly speaking, it's not a big loss because three Russian arbitration institutions which have special rules for corporate disputes so far have not registered even one special corporate dispute listed here in red. So although there is a possibility of submitting such dispute to permanent arbitration institutions, so far it is not on a high demand. How the status differs SIAC, for example, from LCA or Stockholm institution with no permanent arbitration institution status in Russia. There is some significance. Lack of PI status does not mean that the foreign institution is not allowed to administer disputes in Russia. For example, LCA or Stockholm still could administer disputes, international disputes with place of arbitration in Russia. However, the award issued by such institution is considered by Russian law as issued in ad hoc arbitration proceedings. It's not a real ad hoc arbitration, but for the purpose of Russian law, it is considered as ad hoc. What does it mean in practical sense? It means that foreign arbitration institution without PI status would not be able, for example, to apply to state court or tribunals, would not be allowed to apply to state court for interim measures in support of arbitration, or the parties to such arbitration are not able to exclude possibility to challenge of the arbitral award before Russian courts. But in case of SIAC and ICC, they could put a clause that the award issued under the rules of SIAC, for example, in Russia is final and not subject of review by Russian state court. This is pretty important advantage. And this provision has been tested already by Russian Supreme Court. There was a pretty well-known in Russia case involving Siemens, where initially the question was whether Stockholm Arbitration Institute is allowed to issue an award with place of arbitration in Russia. And this case came to the Russian Supreme Court, and Russian Supreme Court finally confirmed that arbitral award issued by Stockholm Arbitration Institute with place of arbitration in Russia is valid, and lack of special PI status means that this award is to be considered as award issued in ad hoc proceedings, but does not make this award invalid or enforceable. There's a big question with regard to domestic arbitration. I think it's a very big question for many Russian companies, including Russian companies with foreign investments, because Russian law prohibits foreign arbitral institutions without PI status to administer Russian domestic disputes, and with PI status as well. And if the parties will choose foreign seat, for example, Singapore, this prohibition is still in force. So if, for example, one of the parties will come to Russia for enforcement of SIAC award with place of arbitration in Singapore between two Russian companies, there will be certainly difficulties in enforcing of this award in Russia. But in addition to that, the question would arises, is there any liability of arbitration institution for administering Russian domestic disputes? Because Russian law prohibits it, and the license issued to foreign arbitration institutions by Russian Ministry of Justice also prohibits administration of domestic awards. As a kind of way to resolve the situation, the working group number 2 at the Council of Promotion of Arbitration at the Russian Ministry of Justice issued a note. And the essence of this note is that if foreign arbitration institution does not actively promote that it administers domestic disputes, it does, and also informs the tribunal that it, under Russian law, a foreign institution is not allowed to administer domestic disputes, then it does not have any liability for this arbitration proceedings in breach of Russian law. The logic behind this note is that the decision on jurisdiction is taken by the tribunal, not by institution. So if institution warns the tribunal that there are restrictions under Russian law, but tribunal nevertheless proceeds with arbitration, there could be potential liability of arbitrators, but not of the institution. Well, this explanation does have a sense, certainly. The big question, of course, what is the legal force of this note? Because as I mentioned here, this is a note of working group at the Council of Promotion of Arbitration at the Russian Ministry of Justice. It's like a note issued by brother-in-law of the secretary of the assistant of the judge. So the legal meaning and the legal force of this note is pretty questionable, although, as I said, what was stated here does have sense. A couple of words about statistics. This is my final slide. How many arbitrations were held in Russia with a place of arbitration in Russia by various institutions? If you look into this chart, frankly, there were not so many arbitrations. There were cases under ICC rules, there were some cases under Stockholm rules and LCA rules. By the way, all these cases were conducted where neither of these listed institutions had permanent arbitration institution status in Russia. So far, there's no statistics of SIAC, HKC, and VIAC with regard to places of arbitration in Russia. So from one side, one could say that having a possibility to administer disputes in Russia is not a big advantage for various reasons. And one of the reasons is that Russian seat generally is not extremely popular even for Russian companies. From other side, I think in terms of promotion, this is a pretty good sign for foreign institutions that it is allowed to administer arbitration with place of arbitration in Russia. Secondly, it could be used as a tool in bargaining with foreign counterparty when you represent Russian party. If foreign party, for example, wants to submit dispute to arbitration under SIAC rules, Russian party would say, okay, but let it have seat in Russia. So this is in short what status of permanent arbitration institution gives to SIAC and other institutions and how it is different from other institutions without receiving this status.
Thank you, Vladimir. In my capacity of moderator, I can ask some questions if that's okay. And I will also invite other panel members to invite, to ask questions. And of course, the participants. I still do not understand the significance. And I must have disclosed my conflict of interest in the beginning when I introduced all speakers, but I never introduced myself. I'm based in London. I spent time between London and Moscow, less and less so because of pandemic. But in any event, I've always been slightly skeptical about the arbitration reform in Russia to begin with. I do not share the view that one can properly regulate arbitration. Once you regulate it, disputes run away. And this regulation of arbitral institutions is, to some extent, still something I'm not excited about, even though a number of years has now passed. Are there still practical advantages? Because even with this slideshow, which is eye-opening, I find eye-opening in terms of statistics and in terms of the actual regulation, are there advantages having a license apart from pure marketing or business development tools? What is your view?
David, corporate disputes, I think is important advantage, because when you have shareholders agreement between Russian and foreign company with regard to the shares in Russian company, and you want to submit it to foreign arbitration institutions, this license gives certainly to SIAC advantage. Place of arbitration, as demonstrated in the slide, is not place of arbitration in Russia. It's not really advantage by itself. First of all, because, as I said, unfortunately, it's not extremely popular to submit disputes to arbitration in Russia because of contradictory sometimes practice of Russian courts. And even foreign institutions without license still could have place of arbitration in Russia. But corporate disputes, yes, this is a real advantage for which gives SPI status.
And another point I find interesting is even speaking about sanctions and liability of arbitral institutions. Again, I don't think the terminology, sanctions, liability, etc., for breaching some regulations is something you would come across in the Western or foreign context in terms of arbitration. sanctioning arbitrators, sanctioning institutions. Well, the world is changing, and we'll hear about sanctions generally, but this is different type of sanctions. Here, you've mentioned sanctioning or having liability for administering something, but they're not supposed to administer under Russian law. How serious do you think this situation is, and should foreign arbitral institutions worry about being sanctioned or their arbitrators being sanctioned?
Well, David, you're absolutely right. I mean, governments should not even think about sanctioning of arbitration institutions, because this is a threat and pressure which could potentially put on institutions, because institutions are in difficult position. From one side, when they publish their rules, they make a public offer to potential users. And if two Russian companies decided to include SIAC arbitration clause into the contract, they accept the public offer, and SIAC is under obligation to administer domestic Russian disputes, even if PIE status doesn't allow it. But I think the real problem is that if everything is okay, then nobody will care about it. This is the reality. But if, for example, SIAC will take some award, or let me put it this way, the tribunal under SIAC rules will take some award which will not like some people in Russia, then they will certainly remember that there might be a breach of some Russian regulations, and then Minister of Justice will say, well, because you breached the rules, we revoke your permission. Again, this revocation of permission would not seriously hurt any foreign institution. I don't think so. But in terms of publicity, it could be either good or bad publicity. This is why our position of Russian Arbitration Association were completely in line with your position, David, that administrative regulation is bad for arbitration. It makes the country less attractive for arbitration.
Thank you, Vladimir. I see there are some questions. I'll look at them. But in the meantime, let us proceed to the next speaker. And our next speaker, as I've mentioned, is Anna Zabrodska. And Anna is going to take over from Vladimir, speaking about Russian arbitration and what are the recent developments there that we all need to be aware if we have an arbitration seated in Russia, or if we have an award to be enforced in Russia. So Anna, the floor is yours.
Thank you, David, for the introduction. First of all, good morning and good afternoon, dear colleagues, and our international audience for joining us for this webinar today. So I will proceed with the recent developments in the international practice in Russia, which arbitration practitioners have to be aware of if their arbitration are seated in Russia or the enforcement is needed to be in Russia. And my short review will be mainly based on the latest clarification by the Russian Supreme Court, issued in 2019 in the form of the resolution of the plenary session, which sum up some recent developments in this area and clarified the approach of the Russian courts to some important issues, or just confirmed an already established practice. Anyway, this is good to know for the parties who opt for a Russia-seated arbitration, what they will expect there. And to start with, I would like to say that it's clear for everyone that the seat of arbitration is the territorial link between the arbitration itself and the law of the place where that arbitration is legally situated, which for the case we're discussing today means that an arbitration seated in Russia will be conducted within the framework of the Russian arbitration law. And it's obvious that the place of arbitration is not the same as the location of the arbitration institute or the hearing venue. So why I'm stopping and discussing this kind of obvious thing? Because previously the Russian judges has problems with that and sometimes viewed holding a hearing in a place other than the place of arbitration as a violation of the arbitration agreement. And thus, one state court refused to recognize and enforce an arbitral award of the Arbitration Institute of the Stockholm Chamber of Commerce due to the violation of the arbitration procedure agreed by the parties. And the reason for that was the fact that arbitrators held the hearing in Stockholm, while the place of arbitration was Moscow. And the same confusion was also noticed in the notorious Singapore arbitration case. And to avoid this misunderstanding and further confusion, now the Supreme Court clarified that the place of arbitration doesn't have to be the same as the location of the arbitration institution. Under those rules, the arbitration proceedings are held or the venue of the hearing in the case. Other major procedural consequences connected with the choice of the seat is that the challenge of the final award or the challenge of the separate award on jurisdiction will be governed by Russian law on arbitration or Russian procedural law. And Russian arbitration law provides a possibility for parties to agree that an arbitral award would be final, in which case it wouldn't be subject to setting aside. And here I would like to again point out what Vladimir has already said while he was discussing the benefits of having the license from the Russian Ministry of Justice, is that if this right of the parties to waive their right to bring an action to set aside an award can be applied by the parties in arbitration, but not in ad hoc arbitration. And we remember that if the arbitration proceedings with a seat in Russia is administered by the foreign provider without the license from the Russian Ministry of Justice, these proceedings will be treated by the Russian court system as an ad hoc arbitration, meaning that this agreement by the parties will be simply invalid in Russia. Also, Supreme Court further clarified on that issue that an agreement on finality of an arbitration award shall be expressly set out in an arbitration clause, and that's the same provision contained in the arbitration rules the parties agreed to apply to the arbitration is not enough. And another important thing is that an agreement on finality for an arbitral award would not exempt such award from being challenged based on the grounds of the violation of public policy or non-arbitrability of the disputes. About the question of the challenge of the separate award on jurisdiction, the Russian arbitration law contain and well establish the principle of competence and empowers the tribunal to decide on the issue of its own jurisdictions, but also provide the parties the right to challenge that. And the only way to challenge the jurisdiction of a Russia-seated arbitration tribunal is established by Article 235 of the Russian Arbitration Procedure Code, and required the party to apply to a competent court with the application on setting aside an award on jurisdiction. The Russian Arbitration Procedure Code provides for 1 month to the parties to file an application on challenge of the jurisdiction. But at that, the state Supreme Court clarified that this is the right of the parties. This is not an obligation. And therefore, according to the Supreme Court, the failure of the parties to challenge the award on jurisdiction with the state court on tribunal have confirmed that it has its own jurisdiction will not prevent the filing of an objection against jurisdiction in the course of setting aside of an award or on the stage of resolving the matter of its enforcement, which is important clarification. Now, turning back to the trends in the enforcement proceedings in Russia, I would like to start with a very interesting study published by the Russian Arbitration Association some time ago. based on the detailed analysis on publicly available rulings from 2008 until 2017. And these key findings pretty much reflect the main trends in enforcement in Russia, which are still in place today with fewer exceptions. So the first finding that was announced by the Russian Arbitration Association, that the overall success rate of recognition and enforcement application until 2017 was fluctuated between 80 and 97%. That the most commonly used grounds to oppose enforcement used by the parties or by the court was violation of the public policy, was a lack of the proper notice of the parties or inability to present the case, or the access mandate by the arbitral tribunal. The public policy ground was the most popular one, and it was successful in 39% of all the cases in which it was invoked. Another interesting finding was that the higher amounts awarded tended to correlate with a higher likelihood of refusal to enforce an award. And another finding is that high instance courts tended to refuse more enforcement applications than lower instance courts, and that the average time from the date of the enforcement application to the date of the final ruling is approximately 5 months, which evidently shows that the Russian litigation is very efficient and quick. So I decided to continue this approach chosen by the Russian Arbitration Association and have analyzed the publicly available rulings on recognition and enforcement of awards made in the last 3 years, starting from 2018. And I can confirm that all these trends mostly remain the same. And the one which is the most disappointing one, which has slightly changed, is the overall success rate of the recognition and enforcement applications, which fell down to approximately 55–56%. And I think that this might be also further confirmed by Roman. And I think the reasons for that might be very much connected with some political tensions or sanctions policy, which have been very heavily developed in the recent years. For instance, as it's shown from the practice, it's difficult to enforce the awards made by the Ukrainian arbitration institutions or in favor of the Ukrainian party against a Russian, especially state-owned enterprise, and so on. So my review of the current trends in practice also confirmed that the top 3 grounds the parties and the court usually use to refuse enforcement remain the same, naming that is the violation of the public policy, the proper note, the lack of the proper notice of the parties, or the access mandate of the arbitral tribunal. But the most, as I said, the most frequently used one and the most problematic one is still the public policy argument. And despite attempts of the Russian higher judicial instances to make some guidelines for the lower court to somehow clarify how to properly interpret the public policy, what has to be treated as a violation or has not, and to somehow limit the type of cases when the public policy argument can actually be applied. The problem is still there, and the problem connected with the overbroad interpretation of the public policy argument by the courts. And I have chosen some, let's say, signs which can show that there might be some risk on enforcement stage. And the first one is the presence of the public element in the corporate structure of a debtor, because Russian national courts still implement a very protective approach towards the Russian state budget and potential damage to it. And they use quite broad interpretation of the public policy argument in this respect. For instance, in one of the recent cases, an English company was seeking recognition and enforcement of the LCAA award against the Russian debtor, and the company was a Russian joint the company Rothschild, and the Russian court refused to recognize and enforce awards based on the following reasoning. So the court considered that the defendant was a shareholder of a number of enterprises, being members of a state corporation group of companies, and thus the enforcement proceedings might have resulted in levying the execution of the shares of such companies. And the enforcement of the ruling might cause harm to the budget of the Russian Federation. And therefore, in that situation, the principles of good faith and prohibition of abuse of rights could be violated, and therefore refused the enforcement of the award with a reference to the violation of the public policy. Another sign which parties has to pay attention to is disproportional liability applied to the debtor. Of course, it's a very subjective term, what is disproportional, but previously debtors use any slight difference between Russian law and a foreign legislation to show that the public policy of the Russian Federation has been violated. And for instance, for quite a long time, the Russian state courts refused to enforce awards on recovery of liquidated damages because there is no such institute in the Russian law. And also the courts refused to enforce awards on recovery of excessive penalties and costs. And Russian Supreme Court back in 2014 made an attempt to outline the general approach to that type of awards and what can be in that situation actually cause the violation of the public policy. And there are some criteria. First is the amount of the damage is so abnormally high that it many times exceeds the amount which the parties could reasonably foresee while signing the contract. Another one is that while approving the amount of the damages, there were obvious signs of abuse of freedom of contract, for instance, by using weak negotiation capacity of the debtor. Thus, in all other cases, if these criteria haven't met, the Russian court has to satisfy the application on enforcement and recognition of their awards. But there are still some deviations in that approach. And also this approach of Russian courts shows that, or demonstrates that Russian courts continue to review awards of the merits, despite the explicit procedural provisions of the Russian law not to do that. And that is not very good thing. Another interesting trend I would like to mention in a topic concerning enforcement is that in the recent cases, we noticed that Russian national courts join for the proceedings a special state body, Russian state body, which is called the Federal Financial Monitoring Service, because the Russian courts kind of afraid of suspicious that it might be the part of the system used by the parties to legalize some suspicious transactions. And I can quote the reasoning why the Russian courts are doing that. So they join to the proceeding this financial monitoring service in order to check the legality of the financial transactions carried out by the parties to the dispute. In other words, to check whether there are signs that judicial system of the Russian Federation is used in order to give a legal form of a document issued by a foreign quasi-judicial body on the basis of which monetary funds can be forcibly recovered from the defendant. So again, Russian courts continue to review awards on the merits. And in conclusion, I would like to say that we still have the same problem with Russian courts when we deal with the recognition and enforcement, and it's connected with its very unpredictable approach, which is based on the specific facts of the specific case, and very much depends on the specific judge and some other things no one can predict. So the main concern when we deal with enforcement in Russia is that it's very sometimes unpredictable what is the result we might get. And this is, I think, all from my side. Thank you for your attention. And I will pass the floor to David and Roman.
Well, thank you very much, Anna. In terms of timing, I suggest we proceed to the next speaker. We'll monitor questions. I certainly have some questions for Anna, and only if we have time at the end, we'll put those questions to the remaining speakers and to Vladimir. Actually, Vladimir has been very good and organized. He's been answering questions whilst online, and I see that some very interesting questions that I wanted to articulate for everyone have been put, and Vladimir answered them very nicely. So let's proceed to our next speaker, to Roman, and then deal with the questions if we have the time at the end. Roman, the floor is yours to tell us about unilateral sanctions and their effect on arbitration.
Thank you, David. Dear colleagues, good morning and good afternoon. Indeed, I would like to address an issue which is not new to arbitration. However, it's been gaining importance in the recent years. And I will speak about the effect of unilateral economic sanctions on international arbitration, and primarily on international institutional arbitration. As you know, unilateral sanctions have been known for a long time. These are the restrictions done by a particular state which are imposed against nationals of another state. And the most notorious examples are those, for example, by the United States, sanctions against Cuba and Iran. But in the past, I would say 1 or 2 decades, the use of unilateral sanctions has increased exponentially as a measure, as a unilateral measure against particular individuals. For example, from 2014 until present, about 500 Russian companies have been designated by the US alone under various national sanctions programs. We see similar restrictions by the members of the European Union, by also Canada, Australia, Japan, etc. And the effect of the unilateral sanctions on international arbitration, the effect is quite striking from what we see. The sanctioned entities experience difficulties when it comes to instructing legal counsel, experts, when they appoint arbitrators, even when they get to pay their shares of arbitration fees or get visas to be present at the hearings outside of Russia. As a result, we've heard a number of complaints from Russian companies because they've been denied access to justice in the conventional centers, in the centers, arbitration institutes they would normally use in the previous years. Well, I'll give you a very simple example, and I think that's a very common example these days. We'll take a hypothetical Russian entity, for example, being under the EU sanctions, and that entity learns that it's a respondent in an arbitration administered by a European Arbitration Institute with the seat of arbitration in Europe and a material law of a European country applicable to the dispute. Of course, for the sanctioned entity as a step 1, you would need to instruct a legal counsel, and it likely be a counsel of a European state which material law applies to the dispute. Now, it could be even a law applicable to the arbitration proceedings, to the law of the seat of arbitration. They could be the same, of course. But given the sanctions, a potential counsel, say in one of the European countries, may require to apply for a license to be able to provide services to the Russian company. And now imagine that how many law firms a sanctioned entity needs to ask before it finally instructs a legal counsel. The similar situation occurs when one party appoints an expert, even arbitrators, and buys auxiliary services such as interpreters, stenographers, hearing venue, requires production of hearing bundles, etc. All these may cause troubles, delays, etc. While this situation is ill, it's not normal, it's not good for arbitration. First, it limits the choice of the best counsel, expert, and arbitrators to the sanctioned entities. And basically, you're not free to choose from the best, but you're left to choose from the rest. You get what you can, not you get what you want in terms of the best counsel or best arbitrators. Now, second, it of course impacts confidentiality, because at each stage you need to disclose what the dispute is about, especially when a law firm needs to get a license to represent a particular specially designated company. It requires a license, and it would apply for a license from the state authorities. And of course, along with the license application, you would disclose information about the dispute, etc., etc. So it's of course it breaches confidentiality. And third, arbitration, we all work against the clock, and it is unacceptable to lose time running between various vendors trying to secure services for a sanctioned entity. If one law firm denies services to you, you apply to another one, etc., and can last very long, and it's detrimental to your position in arbitration, and of course to the arbitration efficiency. Well, step two would be, imagine you would instruct a law firm, but now you need to pay arbitration fees or your share of arbitration fees. And when it comes to payments of arbitration fees, it is an Achilles heel of institutional arbitration, because banks simply refuse to accept wires in different currencies, no matter it's a euro, Swiss francs, US dollars. Banks would be very cautious about wiring money from sanctioned entities into Europe. And that's a huge problem, because most of the European arbitration institutes are not flexible in terms of the payments. If banks refuse to accept arbitration fees, then a company, the applicant, be it a claimant or a respondent, is not able to bring its claims, or the institute is not being to administrate its claims, and it's clearly a denial of justice. And even if you overcome all these two steps, then you get to the recognition and enforcement of the award, and you can be sure that your opponent will raise an argument of public policy against the enforcement of the award in favor of a sanctioned entity. What happens in return? Russia in 2020 and China in 2021 have introduced counter-sanction legislations, which basically permit the targeted companies to disregard arbitration agreements and litigate in local courts. And we see that this action by unilateral sanctions caused a reaction by the targeted countries and targeted persons. Altogether, this situation is serious, and of course it harms arbitration the way we remember it in the old good days. What Russian users do these days, they look for alternative venues, alternative rules, alternative applicable laws. And in order to measure that, as David mentioned, in 2016, we carried out a survey and asked 3 simple questions. What would you use giving a possibility of sanctions against you or against your counterparty under a contract? Well, which law, which venue or arbitration rules would you use? And we asked the same question in 2021, 5 years into the sanctions, or actually no, 7 years into the sanctions already. And the answers were a little bit different. I'm not going to discuss the particulars of the survey. I'm sure you'll find it interesting. We are planning to release it in November. But in terms of our discussion today, I think it is important to mention the position of Singapore and SIAC in particular in that survey, what kind of results were received by SIAC. Well, among Russian users, SIAC rules were named number 4, and they came after the ICC, LCIA, and ICAC Russia. So number 4, in terms of the arbitration rules Russian users prefer to use or prefer to include in the contracts, arbitration agreements these days. If to compare with 2016, I think SIAC was number 7 or number 8 on the list. So now it's substantially improved its position, and it's number 4 in terms of the the rules the users would use the most. The law of Singapore also was number 8 in 2016, but now it moved up to number 4. Again, a clear improvement of its position on in the survey. Only Russian, English, and Swiss laws actually come before the Singaporean law in the results of the survey. And finally, as the seat of arbitration, Singapore received a position number 2. So it's ranked number 2 after Russia as a seat. And I think this is also maybe perhaps due to, Singapore receiving a license and getting more exposure among Russian users, etc. This is, you can see that according to the results, Russian users placed an enormous trust with Singapore. And I hope that Singapore will meet their expectations in terms of what we've just discussed, not only a conventional case management, but also in view of the impediments and problems we are facing these days. As a matter of history, if Russian users start to arbitrate in Singapore, the users from the rest, other ex-USSR states will eventually follow. And in my view, this is clearly a very good news for Singapore. With this, I would like to conclude. Thank you very much.
Thank you, Roman. Again, I have a number of questions, but let's leave them until the end. And Eugene, turning to you now. Could you speak about Singapore and SIAC? And having heard from Roman, could you tell us a little about Singapore's approach to government-imposed sanctions? And is there any particular takeaway for the Russian audience when it comes to sanctions?
My pleasure, and very happy to join all of you, and happy to be the Singaporean holding the flag. We don't have much time, so I'll just have a few key takeaways. So to Vladimir's opinion piece a couple of years ago, there is no country for Russian arbitration. The answer we know is no, there is a country for Russian arbitration. A few good countries for Russian arbitration, as Russian users now found out. Singapore is now ranked 2nd behind Russia. And to the other point raised in a prior Russian Arbitration Association survey, and also in Vladimir's remarks, hopefully Russians no longer see Singapore as exotic. Singapore is not just exotic anymore, not just in the eyes of Russian arbitration practitioners and parties, but also in the eyes of arbitration practitioners around the world. I'll start first with the sanctions point, and it's no secret. It's published on the Singapore government website that Singapore does not enforce unilateral sanctions by a single state or by a regional grouping of states. The only sanctions that the Singapore government enforces are UN Security Council sanctions. So that's very clear. The primary effect of sanctions, therefore, and it's in the way that it impedes arbitration and the way that it's become, as Roman put it, turned arbitration, at least for parties who are sanctioned by subject to unilateral sanctions, very different world. You won't have that primary impediment in Singapore. And what does that mean? That means if you are a sanctioned party of SIAC arbitration in Singapore, you'll have no obstacles. Fee collection is something that's traditionally faced, and Roman's spoken a little bit about this. SIAC's fees are denominated in Singapore dollars, and they're collected by a Singapore bank without the need to use an American US dollar intermediary bank. So that's critical. And there are, as I think Vladimir, you mentioned, you've got some of the SIAC cases. I'm sure you'll confirm that the process of paying fees is very smooth. There are no delays. The issue of secondary effects of sanctions, however, is slightly more complicated. For example, in terms of whether there is a restriction on the number of arbitrators that could be appointed, the nationality of the arbitrators that could be appointed, say, by the SIAC president. They might not be able to consider a US candidate. You might be restricted in terms of candidates that come from US international law firms like myself. But there are plenty of other candidates in Singapore that are very ably qualified that you will not be restricted from. Interestingly, the SIAC is extremely experienced with sanctions because its current president, Lucy Reed, is herself an expert on sanctions practice in the US. And I understand that if an issue were to come up, in fact, the SIAC's internal policy is probably to ensure that the duties of the SIAC president are delegated to a vice president. We have a Singapore vice president, Kevin to exercise the authority of and the powers of the president. So to the sanctions point, no issues. I'll now move on to the not exotic point, and I am very happy to hear the results of the survey, the latest RAA survey in Russia. I mean, they're not very different from the broader global Queen Mary White and Case survey, which was released in May. Many of you may know. In that one, this year, SIAC ranked as the top preferred arbitral institution in Asia and the second preferred arbitral institution in the world. And Singapore as a seat, which naturally is very closely associated with SIAC, emerged as the joint top seat in the world and the top preferred seat in Asia. And I noticed that in Roman's recitation of the recent survey, although SIAC comes in fourth in Russia, it's actually also top among the arbitral institutions from Asia that are on that list. So that's all very good news for SIAC. Very impressive work that the institution has done, considering that it's only 30 years old, and that a lot of the headway that the SIAC has made globally, and indeed Singapore has made, has actually been achieved in the last 10 years. David, I don't know whether you will give me a little bit of time to just take the audience through a few statistics, which I think might always be useful for making the point.
Absolutely, well, we still do have time because our seminar is officially until 1:15. So please do share the statistics, especially this sounds fascinating to me.
Wonderful, thank you. And I won't take long. And I think the first point, maybe for the audience that's less familiar with the SIAC, is it's not exotic. If you're familiar with ICC, LCIA, and Stockholm Chamber Arbitration, or any of the Swiss institutions, then you will find that you will very quickly become an expert and very quickly become a specialist in SIAC arbitration, because the rules, the policies, the fundamental principles behind the rules and the procedures are not very different. Of course, in the detail of the rules, there will be differences, but the SIAC has state-of-the-art rules, and some of which are very innovative. So let me first take you through some key reference points in the statistics. This one might be interesting. You see 1,000 cases handled by SIAC. The key takeaway for you here is 1,000 cases in a year for the SIAC is a huge achievement, because only 10 years ago, the SIAC was trying to hit 100 cases a year. If you look at the total sum in dispute, $8 billion may seem paltry when it comes to the cases involving Russian oligarchs and some of the large investment treaty cases in Europe. But remember what I've just said. 10 years ago, the SIAC was trying to hit 100 cases a year. Today, $8 billion. I'm very confident that watch this space, 5 to 10 years time, this number is going to be very different. And let's talk about foreign users. Unfortunately, we don't see Russian users listed on this slide, but it's important to keep in mind that obviously the way that the nationality of parties is tracked on this type of slide reflects the actual entities that are involved in the arbitration. They therefore don't tell you whether these entities involve Russian investments or not. A lot of the investments vehicles may well be Asian investment vehicles. Over the last 5 years, as Roman mentioned, 2016 was an inflection point. So over the last 5 years, the SIAC has seen a gradual increase in the number of direct Russian parties involved in its arbitrations. There were 2 in 2016, 0 in 2017, but then in 2018, another SIAC inflection point, which is 5, so almost a trebling of cases. 2019, 2, and in 2023, I don't know what the number will be for 2021. But one of the points that's also been shared anecdotally with me is that despite the absolute number of cases being relatively small, the value of the cases that the Russian parties are involved in are high. And some of them, for instance, are in the $100 million and upwards range, probably because they come from the energy sector. So clearly, it takes some time for state-owned enterprises and others to change their policy. These policies typically will involve a lag of at least 5 years at minimum before you start to see them reflected in practice statistics. But we're definitely going to see with the types of survey results of the RAA and of Queen Mary, we're going to see more of this happening. I'll skip over the slide. It's just basically just showing you the different sectors where the disputes come from. I should add that if anyone in the audience is interested in the SIAC slides, I'm sure the SIAC will be very happy to share these details with you. This slide is to show you what I call the 3 E's. These are the innovations introduced by the SIAC to its procedure since 2010. So as I mentioned, for the last 10 years. EP and EA are familiar with to many of you. Expedited procedure is something that was very new and very innovative for the SIAC in 2010, because the expedited procedure is different from the LCIA's expedited formation of tribunal procedure. The expedited procedure basically provides for small cases or cases involving exceptional urgency to be referred to an arbitral panel consisting of a sole arbitrator, even if the arbitration clause otherwise provides for 3. An application is made to the SIAC. And if expedited procedure is granted, then your arbitration is to be completed, or the award is to be rendered within 6 months of the constitution of the tribunal. Effectively, that would approximate to an 8 to 9 month arbitration. And it's one of the most successful innovations by the SIAC. EA applications, again, not new if you are a veteran of ICC arbitration. The ICC started with the pre-arbitral referee rules in the 1990s, but they never really took off because they were not part of the main ICC rules. The AAA in the US introduced emergency arbitrator, the modern name emergency arbitrator in 2006, but that never really took off. That was more of an American practice. It wasn't until 2010 when both the Stockholm Chamber and SIAC introduced the contemporary EA procedure that it took off. And in 2013, the ICC incorporated its old pre-arbitral referee rules into a new format now called also the EA procedure. And that was an inflection point for the SIAC because we began to see that here was an Asian institution no longer just following the Western institutions as leaders, but innovating and also inspiring more traditional or older institutions to follow suit. The next major innovation was in 2016, which is the 3rd E, early dismissals. In 2016, the SIAC became the first commercial arbitral institution in the world to introduce early dismissal procedures, which essentially allow a party to make an application for an early dismissal by way of a preliminary determination, early dismissal of claims that have manifestly no legal merit, or early dismissal of defenses if there is manifestly no legal merit. And this is also definitely something to watch. In 2016 as well, I think the other point is that the SIAC introduced very broad consolidation and joinder provisions, which have also become successful. David, I am watching the clock, so I have more to say, but at this point, I think I will yield the floor back to you.
Thank you very much. This is all fascinating. In the meantime, we have had some questions coming in. And Vladimir has been answering some of them. I just wonder, whilst it's still afresh, when it comes to sanctions, Eugene, you say that it is possible to make payments in local currency, and therefore you avoid problems or potential problems with US banks, etc. What about the arbitrators? And Lucy Reed herself, I suspect is a citizen of a country that would not be particularly happy if its citizens sat as arbitrators and received fees from sanctioned entities. How does that work?
Indeed, David, and I alluded to that by reference to the phrase secondary effects of sanctions. So there are secondary effects insofar as your choice of lawyers. The choice of lawyers for a sanctioned party may be slightly more limited, especially if we're looking to international firms. But there are plenty of sole practitioners, boutiques, Singapore law firms, etc. So there's still a lot of choice. So as far as access to justice is concerned, do you have a narrowing of your field? Yes. Theoretically, but hopefully not to such an extent that you effectively feel that you're denied a neutral, fair, and just hearing.
Thank you. Another question. probably goes, well, to either Vladimir, Roman, or Anna, because Anna mentioned Ukrainian institutions. And I just wonder, have there been, or are you aware of any Ukrainian institutions applying for a license?
I am aware that arbitration court at Atamaken from Kazakhstan, which is Atamaken's Chamber of Commerce in Kazakhstan, applied for a Russian license, and they were denied because Council of the Ministry decided that they're not internationally recognized arbitration institutions, but I have no information about Ukrainian institutions.
Me neither.
Thank you. Thank you. And Roman, can you share with us more from the survey? Is there anything else that we should be aware, something eye-opening or revolutionary as a result of the survey?
Thank you, David. Indeed, there are interesting findings. We had new questions vis-a-vis the questions we asked in 2016. This year. Back to Eugene's observation about the arbitrators, of course, you can ring fence your management, case managers, actually, presidents such as Lucy Reed. She cannot take decisions on certain things when it comes to the specially designated companies. But why I remember 2016 is because before that, when you would ask an arbitrator, do you provide services or justice? And before the era of sanctions, an average arbitrator would say, I'm just a service provider. So I'm free to get paid for that, for my legal services. But after the sanctions came into effect, most of the arbitrators started to say that we are providing justice. These are not services, so we can get paid for justice. In terms of the findings, one of the most interesting trend we've been observing in the recent years is the increase of the use of ad hoc setups, such as under UNCITRAL rules or under other rules, but in an ad hoc formation to avoid involvement of any institutes, because ad hoc provides for more flexibility in terms of payments and selection of arbitrators, etc. And along with that, the parties were looking into a non-national sets of laws. Instead of using some material laws of particular states, the parties started to use things such as lex mercatoria and all other non-national sets of rules for trade contracts. And as Eugene just demonstrated, trade contracts represent the bread and butter of international commercial arbitration. So I think that what we'll see if institutional arbitration will not adapt to the current situation. I think we'll see more ad hoc under lex mercatoria or other sets of non-national rules.
David, just shortly to follow up what Eugene said about administration of cases by SIAC. From my experience, I have a good example because I have two not related cases but representing the same client. One is administered by the rules of European arbitration institution, one is by SIAC. We are it's pending for more than 1 year in both cases. In European case, we still have not paid the registration fee to the institution because the institution is getting, or bank is getting permission. In SIAC, we paid in 2 days. So this demonstrates the difference between SIAC and approach of European centers.
And the arbitrators, the nationality of
arbitrators are different, but in terms of administrative proceedings and registration fee in SIAC, it went very smoothly. With European institution, it's still a problem.
Well, this is here first-hand experience goes. Now we have probably 1 minute left. Just very quick question to Eugene. Are there statistics on governing law? What is the most used governing law by parties? Because you have now so many disputes at SIAC. What is the most common governing law?
I'm afraid I don't have them on this particular set of slides, but I think the popular, just anecdotally, the popular governing laws more or less match the parties, the nationalities of the parties. So Singapore law is probably one of them, English law, Indian law, because traditionally Indian parties are very involved, always one of the top 3 parties in Singapore. I think these are the common ones, English law, Singapore law in particular. And as you all probably know, English and Singapore law is a common law system and has its roots in English law.
Thank you very much. I'm reminded that we need to finish promptly on time. Thank you everyone at the audience for your questions. Thank you, Viktor Prokofiev, for your questions. You put a number. And sorry if we haven't answered all of them, but we will do it in writing. And again, I'd like to thank all participants and the panel for your excellent presentations. And I hope the picture is clearer, at least to me it is. Thank you all. And
Thank you so much, David, and to all the panelists for that engaging and insightful session. I would also like to thank all the attendees for joining us today for this webinar. We hope to see you at our future SIAC events. Have a lovely evening, everyone. Thank you.